Bryant here. Good to have you along on a great Friday. Why great? Because Good Friday was taken. Good to have you along because we're covering a number of things this hour. We've got the Bryan Kohberger update. Have you heard what's going on in this particular case? We're going to take this little trip to Moscow, Idaho for an update. There was a hearing yesterday for the Idaho murders suspect, Mr. Kohberger. His defense attorneys asked the judge to dismiss the indictments against him entirely, or at least remand the case for a preliminary hearing. Well, Judge John decided that, I could tip it off here and say denied, but anyway, here's the basis for this motion. This is what is the most creative part of this process. Kohberger, who's accused of murdering those 4 University of Idaho students, is basically saying to the court that, hey, that whole grand jury indictment thing, it's really not done properly, and as a result, any indictments against me should be dismissed. Let's go to that hearing now. Listen to the arguments, both from the defense and from the state.
So, we're here now on the defense motion to dismiss indictment on grounds of error in grand jury instructions or in the alternative remand for preliminary hearing. So Mr. Logston, I believe, is going to present the argument.
At issue in this particular case is Idaho Code 19-1107, and the infamous language in it that says that grand jury ought to find indictments when all evidence before them taken together, if unexplained or contradicted, would in their judgment warrant a conviction by a trial. And the first question that a court has to ask is, what does that mean? And you start with the plain language, which we argue what warrants a finding or a conviction by a trial jury is beyond a reasonable doubt. And it meant that back in 1887, when the territory took all of these statutes, almost entirely from the state of California, and it means it today. And then we also pointed out that the great state of California, when they had these on their books from back in the 50s, had already a case in 1962 where they said that it's clearly something more than probable cause, but they weren't too specific about exactly what it meant. While the state of New York is trying to figure out ways to not have to abide by the language of what would warrant a conviction by essentially saying, if you can tell the grand jury that is their burden, but you can also tell them the probable cause thing. As long as they hear both of it, it doesn't really matter. And then the state of Idaho says, well, that's not even what that means, without any additional explanation for what they're talking about. And California apparently just kind of forgets about it until sometime after they've already passed a law in the 40s that says you can only dismiss a grand jury indictment if you can show that there wasn't probable cause. That kind of moods the whole situation because they've obviously fixed it by statute. Our situation is such that we have this thing on the books, and the only group that seems to really dislike it is our Supreme Court, who keep having these opinions where they're like, please, prosecutors, stop telling people it's beyond reasonable doubt. This happens in the early 1900s, and it continues until the 80s, when they finally say, look, we passed a rule. I hope it's clear now. Stop saying that your burden is beyond a reasonable doubt. I'm just pointing out that there's clearly prejudice in the record that the court can see from what they want being instructed. It's also, as we argued, clearly going to be fundamental error. You tell the grand jury that this is the standard and it's actually something else. You can't possibly think that the result that you're getting is the accurate one, and so you have to do it again. And these are fundamental rights that people have, so clearly that would be the way to go.
Mr. Nye?
Thank you, Your Honor. As much as I enjoy the knowledge of legislative history, as a trial attorney, we usually have a shortcut, and that is we check to see if the Idaho Supreme Court has ruled on the issue, and in this case it has multiple times. So in Edmondson, the Supreme Court said, and I quote, The purpose of the grand jury proceeding is to determine whether sufficient probable cause exists to bind the defendant over for trial. The determination of guilt or innocence is saved for a later day. As long as the grand jury has received legally sufficient evidence, which in and of itself supports the finding of probable cause, it is not for an appellate court to set aside the indictment. This court is bound by that holding. The Idaho Supreme Court applied that holding in 2 subsequent cases, Martinez and Jones, both cited in my brief. The Court of Appeals has applied that holding repeatedly. This court is also bound by its holdings. The only other thing I would add is, to summarize Mr. Allison's argument, Idaho law supports it as long as you ignore the Idaho Supreme Court. California law supports it as long as you ignore the California Supreme Court. Idaho's constitutional history supports it as long as you ignore the founding fathers. I could go on, but there's nothing to see here. The Idaho Supreme Court has ruled on this, and this court is bound by it. Unless the court has any questions, I'll respond to my brief.
Thank you, Mr. Nye.
Thank you.
So sometimes in the real world, in a case in which you think you have anticipated all of the other side's positions and arguments, you get surprised by one that it seems to be so far afield that you never anticipated it. I have to figure that's what the prosecution thought in this case when the defense brought a motion effectively to dismiss an indictment because of a burden of proof analysis, which sounds like settled law. Luckily, Catherine Lizardo is here, Philip DeBay, both to help me understand what they were attempting in this Kohberger case. Philip, you're a defense dude, so tell me, was this just something they needed to put on the record, have denied so they could take it up? Is it just another element for any ultimate appeal? What's the purpose here?
Particularly in a capital case, Michael, it's incumbent upon counsel to try to assert and argue every procedural and substantive right of a defendant because of the great life interest, if you will, in the case. And when I say life, meaning under our due process, can't be deprived of, life, liberty, or property without due process. In this case, it would be a death verdict if the jury finds, first of all, that he's guilty and that the aggravators outweigh the mitigators. Now, having said that, if we're really honest, just historically and even under modern law, if a grand jury were to find somebody should stand trial beyond a reasonable doubt, if you really think about it, it would almost obviate the need for a subsequent jury trial after jeopardy attaches. I mean, why would you need it if they've already proven it? The whole spirit of a probable cause hearing or a preliminary hearing or a grand jury hearing is to give the court a snapshot of the evidence to see if somebody should even stand trial. It's not whether or not they did it definitively, but whether or not there's enough to give to a jury to find beyond a reasonable doubt that the crime occurred. And the U.S. Supreme Court case precedent is pretty clear on this, that the standard is probable cause. And in fact, even in just the grand jury indictment process, the courts have held that if the grand jury itself is properly and lawfully impaneled, you don't even get to set aside the bill of indictment, if you will, even if some of the evidence itself is insufficient, as long as the grand jury itself was properly impaneled. So to extrapolate from that you get a finding or that the jury's supposed to find beyond a reasonable doubt that they stand trial, I just don't think is rooted in law.
No, it's been well settled, as I've suggested. So let's, Catherine, stay right where you are, because I want to get your take after we hear from the judge. Let's see if he surprises us. Here's his ruling.
Thank you. I appreciate the argument. I think it's really creative, and I appreciate the journey back through history. I think it is an important factor in determining what the law is and why the law was established the way it was. But even you, okay, and I've heard this, but even in your brief, and this is your quote, okay, that the whole of modern jurisprudence on the issue is against it, as well as the least one founding father of this state. So I get it. I mean, what it comes down to me is that I am constrained by what I believe is settled law in Idaho. I may be wrong, but this is certainly an issue that you would have to bring up with a higher court, like the Idaho Supreme Court. But the Idaho criminal rules, specifically Rule 6.5A, expressly states that probable cause is the standard, not beyond a reasonable doubt, and for a grand jury's indictment. And I think I have 3 or 4 recent, because this argument has been circulating in the state. I think I've had 3 or 4 district judge decisions denying the motion and the argument. So I am going to deny that argument. I think the argument is good, but I can't go that far. Not today.
And denied. So, Catherine, not a surprise whether this goes anywhere on appeal or some sort of writ. You know, I seriously doubt it, because it is, quote, settled law, which is a term of art. It isn't just thrown out there. There's not a real dispute. But, Catherine, it is a good argument to get rid of the grand jury process. And we hear that talked about a lot, where you just have an information from the prosecutor and the charges are brought using that vehicle. What's your take on that?
Yeah, I think, like you mentioned, it's not a surprise that Judge denied that motion, and he's very nice to say that the defense argument was very creative. What I found interesting with what he said, though, is that he's seen about 3 or 4 other arguments and ruling relating to similar arguments in Idaho. I wonder what's going on behind the scene, because as we heard, he said that you have to take it up to the Idaho Supreme Court. So are they trying to plan all of this orders up, the 3 to 4 or 5 now, other orders denying such a motion, so that they can bring it up to the Idaho Supreme Court? Procedurally, that's always an interesting thing for me to know as to how they're going to try to prove that kind of argument.
And if it were to go beyond the Idaho Supreme Court, you know, the U.S. Supreme Court would have to have a reason to take it. And I can't think they'd find that it's unsettled, that they need to step into this mix. You're in the trenches there, Philip. Do you like the grand jury process?
You know, it's interesting. I've only had one grand jury case in my entire career. All felonies, well, I shouldn't say all, but the bulk of them, at least out here in LA County, are preliminarily decided by a magistrate at a probable cause hearing, or what we call the preliminary hearing, where a judge hears the evidence and decides whether or not a defendant should stand trial. But in a case of this magnitude, it really was incumbent upon counsel not just to cite controlling authority for this idea that that the grand jury should have found beyond a reasonable doubt that there was enough evidence to make him stand trial, but counsel also ethically is required to cite opposing authority, so that you don't mislead the court, if you will, in making a decision on such an important issue. I highly doubt, I really do, that a higher court is going to reverse this court on those grounds. And let's just pretend they did, Michael. I do believe that if there was a do-over and going back to the grand jury, there was enough to make him stand trial beyond a reasonable doubt, because the DNA on that sheet found on the bed where one of the victims lay. Yeah,
but the point you make is so important here. If the grand jury is going to use that standard, what the hell do we need a jury trial for, or a bench trial?
Yeah,
it makes no sense. It's redundant. So I don't know. I kind of see the grand jury process fading away. I've seen it in a lot of jurisdictions already. So we'll keep you posted on the Bryan Kohberger case. Of course, we've blown through what was one of the originally planned trial dates, but it's going to happen next year. We're sure of that. Let's take a break. We'll come back more on Law and Crime right after this.